Good morning, everyone. So excited to have you in our webinar today. We'll wait for more people to kind of slowly jump onto that link. And Simon and I have a bit of an icebreaker that we're going to do today. Simon, you know what the question is. I wanted to know what you're up to during the Christmas break. Anything exciting?
Uh, yes, well, exciting. I'm not sure if that's the right word, but I'm going to see my in-laws in Parks, New South Wales, which is a wonderful regional town, sort of west of the Blue Mountains. So you go
Like,
through Lithgow and Bathurst. And then Orange, then you get to Park. So I'll be there for Christmas, and then we're going to see some friends in Pottsville, which is up by the New South Wales Queensland border. So there'll be lots and lots of driving with three little children in the back of the car.
I was gonna say that's gonna definitely be. I remember every time I'd leave and with my mum on a massive road trip or anything when I was a kid, I'd be the first one to be like, "Mum, feeling a bit car sick, or something's going on, or we've left this behind." So make sure you're well prepared,
Yeah,
Simon.
there'll be lots of that. And how about you, Sanam? Where are you going to be?
I'll be hunkered down in my regional town, waiting for my mum and my dad and some family friends to come visit during Christmas. So it'll be a lot of hosting, probably a lot of time and hours spent on that, more so than any driving or anything this year. But I'm really excited, Simon, about your trip. I feel all I can sense is that it might be a bit hot and a lot of heat as you progress through Orange and get to parks. So yeah, they'll but definitely I think the furthest I've ever gone is to Orange, and it's absolutely lovely, right? Going out that side. So that's going to be very exciting.
Yeah, yeah, no, it's going to be great. It's going to be
Oh,
great.
that's awesome. Well, I mean, I think we've got quite a few people jumping on. I can see onto the link. We'll give it another minute or so, but it'll be very exciting to hear from you guys. What are you guys going to be up to during the close down and the Christmas break? We've got a Q&A section, which I'm sure Sophia won't mind if you add in a few bits and pieces around what you guys are going to be up to, and then at least we'll know what everyone's doing.
Yeah.
Perfect. So.
Yeah.
We'll give it another minute. Simon, is there anything else that's exciting that's happening for what about New Year's? Anything going on there?
I'm not a big New Year's person. I'm usually in bed by 10 p.m. So and that's a late night for me. So yeah, no plans for New Year's as such. How about you?
I'm the same. I feel like it's daunting to even think about going towards the CBD and wanting to be in amongst all the crowds while fireworks are going off and everything. It's great to watch it on TV, but even then, like you said, Simon, a lot easier to clock off at 10 rather than trying to stay up until the midnight. Yeah, but yeah, no, I'm sure it'll be really really beautiful and absolutely gorgeous to go in person and see it. But it's just the crowds. I can never do it. Oh, awesome. Well, what we'll do is we'll kick things off, I think, because we've got a lot to cover. Simon's definitely got a lot going on here. And I just wanted to say thank you to everyone for joining us today for our webinar that, to be honest, I really thought we were going to just do a little bit of a sequel, but now it looks like Closing the Loopholes is getting a trilogy. So we are very excited to come back with the third installment with Closing Loopholes. And today our webinar is going to be looking at those loopholes that have been closed, as well as looking at what's ahead for 2025. So my name is Sanam. I'm the Employment Counsel here at Employment Hero, and I am joined by none other than Simon Obee. Simon has been here for so many webinars, and he is an absolute powerhouse, head of HR advisory, all the way through to principal lawyer at EI Legal. Simon, thank you so much for being here.
That's okay. It's a pleasure. Yeah, I look forward to these things. So yeah, really great to be here.
Oh, that's awesome. And can we get a little bit of background about you? Because I always love hearing about your experience.
Yeah, so I was an employment lawyer for about 10 years in England, and then I came out to wonderful Australia, and I've been here for about 11 years, working at different places. But the last seven or so, I've been at Employment Innovation and then Employment Hero, the same kind of group of companies, but we're now one big happy family. And yeah, throughout that time, yeah, employment law and HR stuff has always been my bag. So yeah, really passionate about helping business owners, particularly small businesses, in any way that we can.
Oh, that's awesome. And you're absolutely right. I'm also more passionate about employment law probably than any other area of law. And I believe it's because it brings the passion and the fieriness of law, but then you also get the people side of it. Whereas, with other areas like commercial, you're kind of sat behind contracts all day. So it's really lovely to hear about your experience and where your passions lie. So I'm excited for us to kind of kick things off. But before we do, I just wanted to say that we have time allocated at the end. This is a live Q&A webinar, so we love these. We love to get to as many questions as we can at the end. So absolutely use the Q&A button at the bottom, enter the questions in, and we'll see what we can get through to. If we can't get through everything, then we will try to get to as many after the webinar, maybe in post-webinar information or FAQs that we send out. Aside from that as well, this will be recorded, so just keep that in mind. Simon's going to cover a lot of different things, so don't worry about having to frantically write everything down. We will try to make sure that you get as much information after the webinar as possible. And then a last couple of things from me, which is to do with the disclaimer. This is something that we're providing to you in good faith, and we are providing this to you based on our knowledge and our understanding. Of course, the great thing about having Simon here, as always, is that he works at EI Legal. So if you have any specific advice that you need, then trust me, you have a lawyer to hand that you can always reach out to and speak to about any employment law issues. So aside from that, Simon, with the agenda that we've got on today, what have we got going on? We've got a little bit of recapping when it comes to closing loopholes, all the way through to looking at what lies ahead for 2025. And when Simon and I were chatting, I was like, there isn't too much, right, Simon, that we need to talk about? And Simon's like, well, let me tell you, there is a lot for 2025 that we still need to cover. So how are you feeling, Simon? You ready to kick these things off?
Yeah, let's do it. Let's go.
All right, let's go. So we'll start off by looking at workplace delegates, as you can see on the screen. And we've heard a lot about this, Simon. We've heard a lot about the delegate rights changing. And in our previous webinars, we discussed it. But then I thought this was all done and dusted. So now I'm a bit surprised. Is there anything that we need to be aware of? What have we missed?
Yeah, so you're right. It was back in December 2023 when the changes for workplace delegates were introduced into the Fair Work Act by the first tranche of closing loopholes amendments. But then we had some clarification of the law in July. So there is a bit of change there that's happened throughout the year. So I'll just give a quick overview of that. There's a lot more information on all of this stuff in the slides, so I'm just going to scratch the surface, but we'll send you out a copy of the slides so you'll have all the information you need. So a workplace delegate is an employee in your business who happens to be a member of a trade union, and then they are elected by the union to be their representative in the workplace. So when we talk about a workplace delegate, we're not talking about an employee of a trade union who works for the union and comes to visit your business. We're talking about one of your own employees who's been appointed by the union to be their man or woman on the ground, as it were. The one question which comes up always whenever we talk about this is, do I have to have a workplace delegate in my workplace? And the answer is no, 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 you don't. It's not compulsory. But if you're informed that a workplace delegate has been appointed by the union, then you need to understand your obligations in respect of them. They have rights to represent colleagues in disciplinary procedures and in other matters, and they also have a right to take paid leave that the employer has to pay to do training with the union. So if you're not in a unionized workplace, you might not come across this, but if you do get notified you have a workplace delegate appointed, you need to understand what your obligations are. What happened in July was some clarification about workplace delegates' rights. for award covered employees. In particular, it specified that the amount of paid leave they're entitled to for training with the union is 5 days in the first year of employment and 1 day thereafter, but also some other clarifications about their rights and obligations. If you do have workplace delegates, a really good idea to have a policy in place explaining, how you're going to interact with them and the rights of other employees in the business to choose to be represented by the delegate or not. So if you need any more information about that, do get in touch. It won't affect you if you don't have any union members in your workplace.
Oh, perfect, Simon. And we did get a question that came in. I know normally we answer them at the end, but we did get a question that came in around what conditions apply. So like Simon said, it's mentioned on the slide, and then absolutely we will be sending out information specifically around the previous webinars that we've done. And that has quite a lot of detail around the conditions and all the information that you need to know around that as well. So now we're kicking off into another area and another topic, which I think is quite interesting, because the right to disconnect, Simon. Oh my goodness, did we hear so much about it over the last few months? Everyone was talking about it. It seems like we've heard a lot going on, and now all of a sudden we're in a bit of a lull. No one's talking about it. So are employers still needing to be on alert? Am I still going to go to jail? I'm a bit confused about what's going on.
No one's going to jail, and I think the key takeaway is, as long as a business is acting reasonably, then the right to disconnect shouldn't really be any impediment to kind of business as usual. So that's the kind of key takeaway. It's nothing to be overly concerned about. So how the right to disconnect works in a nutshell: it was introduced for businesses with 15 or more employees from the 26th of August 2024. Smaller businesses, it will come into effect 26th of August 2025. And what it does really simply is it gives employees a right to refuse to respond to contact about their work outside of their working hours. So once they finish for the day, once they're on leave, etc., they can ignore contact from their employer or from their manager, their colleagues, or a client, etc., etc. But, and here's the big but, only insofar as that is reasonable. In other words, reasonable out-of-hours communications are still allowed, and they always will be. And we get a lot of questions when we talk about this from businesses who will be, for example, global businesses. They have employees in different time zones. It's to get things done, there needs to be some out-of-hours communication, because otherwise no one's working at the same time. Or we'll get questions from businesses or organizations in the care industry. It's absolutely necessary that in some situations employees can be contacted outside of their working hours to deal with an emergency with a participant, or to change its roster, or that kind of thing. If that is a fundamental requirement for your business, then it should be fairly straightforward to establish that level of out-of-hours communication is reasonable. If it is, if that's what is needed for your business to operate, then it shouldn't be a problem. I think the two things I would add to that, though, are: number one, obviously try and keep out-of-hours communications to a minimum. If it's something that can wait until tomorrow, and when the worker's back in the office or working from home, whatever it is, don't contact them unless you have to. And number two, manage expectations from the start. That is the key to establishing that your practices are reasonable. Make it clear from day one for your employees what level of out-of-hours communication is required, so that if they've been told that from the start, if it's in their contract, if it's in a workplace policy, very difficult for an employee to then say, well, that's unreasonable for you to require that of me now. And linked to that, I would also say if you're paying employees, you know, a decent salary, especially if it's kind of over the award minimums, link that remuneration to the fact that some out of hours communications is required. In other words, say in your contracts, you're paid, you know, your salary is set at this level with the expectation that there will be some out of hours communications, and if possible, set out, you know, what those look like. Is it just in an emergency? Is it to deal with a change in roster, whatever? So a lot more information on the slides, together with some top tips for compliance. But as I say, key takeaway, nothing to really worry about as long as you're keeping those communications to just when they're necessary.
Brilliant. And one of the things that came through was around, you know, this particular clause being in the contract, but also with the award, Simon, that are mentioning, you know, the right to disconnect in there as well, or if the person's on an award, would it still be a requirement to put it in the contract? Would that just be the safer bet in terms of
Yeah,
covering?
I would recommend that if you have a requirement that employees are going to have some out of hours communications, it should always go in their contract. The awards are going to deal with things like payment, you know, is there an entitlement for an on-call allowance for the employee being on call, that sort of stuff. But the award isn't going to tell an employee specifically to their role is out of hours contact required or not. So I think you should put it in a contract, would be my recommendation, generally speaking.
Oh, brilliant. And that's good to know, because I think a lot of times it just seemed like, oh, we'll just have a policy in place, or we'll have a chat to the employees. And like you said, going that extra step further will make a huge difference, especially when you're setting the parameters around somebody that might have to actually be working after hours, given their role as well. So
Yeah.
yeah. Oh, that's fantastic. And so another area that's actually changed, which I'm finding quite interesting, is around casuals and contractors. Being in New Zealand, I feel like Australia is shifting a little bit in that direction, or going back to what it was before. And misclassification of workers is one of the biggest issues we see, right? Whether it comes to payroll, whether it's to do with compliance and employment law. What are the changes that have come into place this year that employers need to be aware of? Because it can be costly mistakes, right?
Yeah, you're absolutely right. So I think the key change for casuals and contractors is about their definition in the law. So what is a true casual? What is a true contractor? If you get that wrong, then you can be in real difficulty. You know, you can be fined significant amounts of money for getting that wrong. So it's really important if you're using casuals, and you know, we'll come to contractors in a sec, but it's really important that you understand what is the definition of a true casual and a true contractor, because if you're engaging those types of workers, you want to make sure you've got that right. So there's been a change through the closing loopholes stuff to the definition of a casual, which came into effect in August, just gone. And it is very similar to the definition of casual employee that we've had previously. It still talks about, you know, you look at a number of factors, including, you know, a casual will generally have the ability to accept or decline shifts that are offered to them. They will generally work irregular hours, etc., etc. Those factors which are on the screen have been around for a long time. What is changing is the law now says that when the law or a court or the Fair Work Commission, whoever it is assessing whether someone is a true casual or not, they will look at the real substance, practical reality, and true nature of the employment relationship, including any mutual understandings or expectations between the employer and the employee, rather than just looking at the terms of the written employment contract. In other words, you can have an employment contract which says very clearly to the casual, you're free to elect to decline or accept shifts, you won't work regular hours, etc., etc. But if the expectation, if the understanding between the parties is something different, perhaps that was, comments made in the recruitment process about, you are going to have to be at work on Monday, Tuesday, Wednesday, you are going to have to accept these shifts. If the expectation understanding is something different, having a beautifully drafted employment contract isn't going to save you. So really important that you understand how to engage a casual properly from day one is the key takeaway there. The second thing that is changing is there is a change to the rules about casual conversion. So casuals have a right in some circumstances to convert to permanent employment after a period of time, and those rules are changing. The one question which always comes up when we talk about this is, does a casual have to convert? Can they choose to remain a casual? And the answer to that is yes, absolutely they can. Lots of casual employees will want to remain a casual employee because if they become a permanent employee, they will lose their 25% loading, which they won't want. So it is absolutely, all of this it relies on the casual wanting to convert. They never have to if they don't want to. So how the new rules operate is, we previously had a position where in some circumstances employers had to proactively offer conversion to permanent employees. Offer conversion to casuals to convert. They had to proactively go out there and say, do you want to convert? That is being scrapped, and the onus is going to be placed on the casual employee. They will have a right to elect to convert after they've been employed for a certain period of time, but they don't have to. And if they don't exercise that right to choose to convert, then they can remain a casual for forevermore. So that's it in a nutshell. We've got a really good guide that we're just putting together, which goes through all of this in lots of detail with some beautiful little flow diagrams and all of that kind of stuff. So we'll share that after the webinar. Just the other thing to be aware of, the old rules will continue to apply for casuals employed before 26th of August, when these provisions came into force, which means you do need to be aware of the old rules. They'll continue to apply to pre-existing casuals until the 26th of Feb 2025. So yeah, you'll need to kind of be across both for a little while. But yeah, I won't go into the minutiae of it, but we've got some great resources that I'll share afterwards. So that's casual conversion. The third thing with casual employment is the casual employment information statement. Previously, that had to be given to employees just at the start of their employment. Going forward, it has to now be given to casual employees, not just at the start, but at various anniversaries and intervals during their employment. And the details of that, again, are in the slides. The one question which always comes up when we talk about this is, can I just have a date in the year where I send out the casual employment information statement to all my casuals, or does it have to be, on an individual's anniversary 12 months from when they started? And the answer is it is done on the individual start date. So you're going to have lots of different dates, if you've got lots of different casuals, where you're going to have to send out the casual employment information statement on a regular basis. Employment Hero has a great feature where it will alert you to your employee's anniversary dates, and tell you you need to send the statement out. So if you're using our HR software, we got all that covered for you. Okay, so that is casuals. Contractors next. So similar to the changes for casual employees, we have a new definition of a new definition of employee in the Fair Work Act, which affects the test about whether someone is an employee or a true contractor. So important to get that right. If you're engaging a contractor, you'll want to be sure that in the eyes of the law, they are a contractor. Otherwise, you could get into a lot of trouble. And again, the test looks at the familiar factors which we're used to looking at when we're assessing, is someone an employee or a contractor? How much control does the business have over them? Are they able to delegate the work to others at their own expense? Do they have to provide their own equipment, etc., etc.? All those traditional factors for assessing whether someone is a contractor or an employee still apply. But what is changing is, in the eyes of the law, they will look at the real substance, practical reality, and true nature of the relationship, including by way of mutual understanding or expectation. So in other words, your contractor agreement might say the contractor is free to choose how they deliver the services, and they have a huge amount of control over how they do this. The contractor is allowed to delegate the performance of the services to other people. The contract might tick all the right boxes, but if the actual reality, your actual understanding with the contractor is, no, you're going to set the hours they work, where they perform work, how they're going to deliver it, and there's no way that they'd be allowed to delegate the performance of work to someone else. If that's the practical reality, then there's a big risk, regardless of what's in the contract, that they would be found to be an employee. So really important that you have a think about this when you're engaging contractors, and get some proper advice if you need it. And then the other thing is for a couple of groups of contractors, so owner drivers in the road transport industry, and employee-like workers engaged through digital platforms. Think of Uber and Menulog and those kinds of setups, I guess. They are subject to a whole new regime of rights and obligations, including basically an ability to claim unfair dismissal or unfair termination if their services are terminated. So if you're in one of those industries, make sure you understand those obligations too. That was it for my 2024 wrap up, I think, Sanam, before we move to 2025.
Oh, that was done very, very well, very quickly, but we covered a lot in that much time. I feel like we dedicated last time an hour to all of those topics, but at least we have, like Simon said, glossed over some of the bits gone into detail, and we have all of this information that we'll supply to you afterwards as well and provide it to you. So don't worry, you're in for a lot of other information that we're going to be sending out post webinar. And right now we actually have a poll that you can see on your screens. And this poll is really interesting because we want to know what you're actually going through at the moment in terms of preparing, what you've had to focus on for these 2024 changes. What's been the top of your list, and what's been your main focus? For me, I personally think, from what I could see a lot of people speaking about, it seems like the right to disconnect, Simon, but it'll be interesting to see what everyone is thinking and what they're feeling. So we will share the results shortly, and we'll just give you guys a couple of more minutes to pick something, and then we'll see what the results say. But Simon, what do you think? Where are you hedging your bets?
Yeah, I think right to disconnect people worry about the most, but I think in reality it is perfectly kind of manageable. But yeah, I think it got a lot of media attention, and yeah, I think the real change there will be how it kind of just introduces into employees maybe a mindset of being able to disconnect outside of working hours. But whether the law has changed hugely isn't perhaps not as greater impact as people worry about.
Yeah, and you've gauged it right. I mean, it seems like casual employment. 56% of people on today that have voted, they've turned around and said that that is the main change that has had the biggest impact to me. And I can see it from the questions that have come through as well around different scenarios and labor for hire and different things like that, where people are asking questions around it. So it's really interesting to see that that's been a front of mind and the focus. And following that is the right to disconnect, and then independent contractors. Workplace delegates don't seem to be getting much love, but that's fine. Like Simon mentioned, you don't need to be going out asking people to become workplace delegates. So it's great if you've got one, then you're obviously going to have to deal with it, but at least you're not having to go around asking people to do that. So we'll move on now to looking at the what lies ahead, 2025. Big year, it seems, ahead of all businesses and employers. And, Simon, I am constantly seeing such and such business is owing $5 million in unpaid wages. Entitlements haven't been paid correctly. It's getting me a little bit scared because it can be scary for a small business, right? To be seeing all of this in the media. And if you get payroll wrong, it's not like a large corporate. You're kind of stuck with having to deal with this, and it could really be a huge detriment to your business. So now, with all the stuff that's been going on, I've been hearing about wage theft legislation coming in. Should I, along with all the other employers, be packing my bags and going overseas to avoid jail time?
No, you definitely shouldn't. And again, it's one of these things that I think you don't need to be unduly worried about, because as I shall explain, well, number one, this isn't law yet, so nothing's happened yet. But number two, the wage theft provisions are targeting intentional underpayment, deliberately underpaying staff. It's not about trying to get things right, making a mistake, and then getting in trouble. If you've tried to do the right thing, then these provisions aren't going to impact you at all, and I'll go through that. So I don't think anything to be unduly concerned about. So the criminalization of wage theft, it's set up in quite a strange manner, which is that the law won't come into force until the government has published the voluntary small business wage compliance code, which they haven't done yet. But if they do publish it before 1st of January, then the law will commence on the 1st of January. 1st of Jan is the absolute earliest it can commence. But if they don't get round to publishing the code until February or March, then the new provisions won't apply until February or March. But as we understand it, the government is planning to publish the code in time for the 1st of January. Obviously, we're going to have very little time to work out what's in the code. So that is, somewhat frustrating, I suppose. And the purpose of the code is that if small businesses follow what is in the code, then they won't be able to be targeted for wage theft. So it's going to be quite important what's in there, but we're just going to have to wait and see. So as I said a moment ago, the way the legislation has been set up is it is only targeting intentional underpayment of employees. Honest mistakes are not going to be caught. If you have, believe someone in your business is a level 2 under a modern award, and you're paying them that minimum wage, but it turns out they're a level 3 and they've been underpaid, that's not going to be caught. Neither is if there's an error in your payroll system and it's been miscalculating over time or whatever. Honest mistakes are not going to be caught. Of course, you can still be subject to other penalties for underpaying employees for making an honest mistake, but these criminal provisions are only about intentional underpayment, and because of that, the penalties are very severe, a maximum of 10 years in prison or fines of millions and millions of dollars. So there is a real kind of severe penalty regime attached. They those penalties can be applied to anyone involved in a intentional underpayment. So not just the employing entity, it could be the directors, senior managers, conceivably, HR or payroll professionals if they were involved in intentionally underpaying someone. It's going to be very, very rare, obviously, that these things come up, I would say. And they only relate to underpayments that occur after the new provisions that come into force. So we assume it's 1st of January. Any underpayments prior to that aren't caught. Of course, you could have someone who has been with your business for, say, a couple of years and they've been underpaid, and that underpayment will, continue through 2024 and over into 2025. And those underpayments which occur after 1st of January will be caught by the new provisions, but not kind of historic underpayments. And so I think, taking a step back, there are very, very few businesses that intentionally underpay an employee. It's just not what businesses set out to do. So it's really nothing to worry about. I think where the real risk arises for most employers is where you become aware of an underpayment that was, due to a payroll error or whatever kind of mistake it was. It's where you become aware of it, but then you don't do anything about it. And then that underpayment occurs in the next pay period and the next pay period. If you have the knowledge that an employee is being underpaid, but you don't go and fix it, that arguably, from that point on, is an intentional underpayment. So that really is something to worry about. If it comes across your desk that something's wrong with payments to staff, you need to jump on that straight away. There are going to be provisions in the legislation which are called safe harbor provisions, which mean that the Fair Work Ombudsman can enter into an agreement with the employer that they won't prosecute for wage theft. That will generally only apply, I would say, where a business has self-reported to the FWO that there's been an underpayment. Then the FWO are more likely to enter an agreement where they won't prosecute. And of course, for small businesses, if they follow the code, what's ever in the code, which might well say you have to self-report underpayment, you won't be prosecuted. So I think it's really important you get some proper advice if you do discover an underpayment, because self-reporting might be the way to go.
Brilliant. And Simon, can I just also mention one of the things that, as I was reading up about this and looking into it, it seems like, we're kind of focused on the intentional side of things, but like you mentioned as well, if something comes across your desk and you realize that this is an underpayment that has happened, or maybe there have been several instances of it and you choose to ignore it, then that also becomes to a certain extent intentional as well. Is that right?
Yeah, I mean, I think obviously the law hasn't come into effect yet. We haven't got any prosecutions that have occurred yet, but I would have thought an employer allowing an employee to be underpaid when they know it's an underpayment, I think there's a big risk that would be considered an intentional underpayment. It's hard to see how it wouldn't be. So I do think that is the real risk for the vast majority of employers. Nobody sets out to do the wrong thing, but when it transpires to you that there has been a mistake, how do you deal with it? Well, going forward, you're going to want to deal with it really quickly.
Yeah, no, absolutely. And it's good to kind of have a lay of the land, at least as much as we know right now, before next year kicks in. And like Simon mentioned, when we probably won't have much time in terms of next year. So it's good to at least get an understanding and a bearing of what it looks like. And there's been a lot of changes as well that are being discussed and considered for next year around awards. And they're never easy to navigate, Simon. So how does one stay up to date with it other than having webinars like this and you, Simon, imparting some knowledge? So what are the major changes to awards that are coming in, and how can employers actually stay ahead of the curve when it comes to it?
Yeah, there are lots of changes
Yeah.
coming to effect for modern awards. So yeah, I'll deal with what the changes are, and then at the end I'll give you my kind of 10 cents on how to stay ahead of it. But first on the 1st of January, there are going to be changes to the awards listed on the screen. So have a look at those and see if they operate in your business. What is changing is one of three things, I guess. Either the award is being amended to say that an employee can only stay at the lowest classification for a set period of time. So it might say, you can only be classified as level 1 under this award for a maximum of 3 months, and then you must go automatically to level 2. So that's one possibility. Or the award is being amended to say that the pay rate at one of the lowest classifications is increasing as of 1st of Jan. Or the third possibility is it does both those things. New rules about how long you can be at the lowest classification, and new rates. So if you're covered by one of those awards, you need to work out what is changing on the 1st of Jan. We are just about to publish some guidance on that, which we will share. There is guidance about this on the Fair Work Ombudsman's website, but my view is it's a bit misleading what they say. So wait for our blog, which will be spot on. But really important you understand this, because of course, if you've got an employee who you have classified as level 1 and they have been in that classification level for say 12 months, and the award is changing to say that you can only be in that classification for 3 months, that means on 1st of January, those people are automatically going to have to be reclassified as the next classification level and have their pay adjusted. So really important that you understand that. If you don't operate under any of those awards, you don't need to worry. I'll keep going, will I? So the other big change to a certain set of awards is in the aged care sector. The Fair Work Commission determined to make various amendments to awards in the aged care sector on work value grounds. They found that work done in these areas was more complex and difficult than it used to be, and that meant that pay rates should increase, but also that these industries were underpaid on gender grounds. It is an industry which is traditionally has lots of female workers, and they found because of that the pay rates were lower than they should be. So there have been various changes that are being made because of that. So there are going to be new pay rates for aged care workers under the SHADS award. So that would be people working in home care in an elderly person's private residence. There's a new pay rates for those workers, and also people working in aged care facilities. The pay rates are being phased in 2 tranches, 1st of Jan and 1st of October 2025. And for home care workers working in aged care under the SHADS award, there's a whole new classification structure, which you'll need to get your head round for 1st of January. and assistants in nursing, who are people who assist qualified nurses working in aged care. They've previously been under the Nurses Award. As of 1st of Jan, they'll either be under SHADS or the Aged Care Award. And then just announced in the last few days, qualified nurses that work in aged care are also getting pay increases on the 1st of March, 1st of October, and 1st of August, 2025 and 2026. So yeah, if you work in that sector, lots to get your head around. As with all this stuff, if you need more guidance on it, do reach out, because yeah, we've obviously been thinking about this stuff quite a lot. So those are things which we know are happening. Then there is a whole load of other stuff which the Fair Work Commission is thinking about, which is likely to happen in 2025, I would say, but it is not set in stone. So I'll just run through what we know the Fair Work Commission is reviewing currently. Number one is award coverage for employees in the arts sector. If you're in the arts industry, you may be used to having employees who are considered award-free. The Fair Work Commission is reviewing award coverage in that sector. So if that is where your business is operating, you'll want to stay in the know about where they get to with that and what determinations they make about who should be covered by an award. Number two is great news for anyone working in retail. The General Retail Award is being reviewed to make it easier to use. There's loads of provisions in there which are really unclear about rostering and hours of work and all that kind of stuff. Hopefully, we're going to get a new award which is really simple and really easy to understand. Fingers crossed. Let's see how far they get with that, but that will be great for people working in that sector. Number three, this is going to have quite a big impact too, I should imagine. The Clerks Award is being reviewed to consider whether it should have provisions, specific provisions that deal with working from home. So the way that the award is set up at the moment, the Commission believes, the provisions about span of hours and maximum length of shifts and breaks in the day, all of that kind of stuff doesn't really fit well with employees working from home. So they're reviewing the Clerks Award to see if it should be changed. Unions are pushing for employees under the Clerks Award to have a right to work from home unless the employer can show it's unreasonable. So that would be a big change for employers to grapple with, but we'll have to see whether that gets put in the award. But the Clerks Award is being used as a kind of guinea pig, and then these provisions will be considered for other awards too. So that is, that could be fairly significant. Number four, the provisions of the awards in the higher education industry are being reviewed to see if they need amendments to allow for employees to work on a fixed term basis. Having tutors and other staff in higher education on a fixed term contract is fairly frequently done. So the award's just being made sure that they're working as they should be in that regard. Number five, this too is going to be quite big. The 7 most frequently used awards, which is interesting of itself to note what they are: children's services clerks, fast food, retail, hospo, restaurant, and shads. They're being reviewed through the lens of how they apply and operate for part-time employees. They all have slightly different provisions that deal with part-time employees. Some of them say that a part-time employee has to be given a set pattern of work, which is quite frequent in modern awards. So you can't just say you're engaged for 20 hours a week. It needs to be, you start at this time on Monday and finish at this time and have your actual set pattern of hours set in stone. But other awards are a lot more flexible. So these 7 are being reviewed to see, well, what is best practice, and there could be some changes there which will impact employers who operate in that industry and employ people on a part-time basis. Number 6, a number of awards, so the Aboriginal and Torres Strait Islander Health Services Award, the Children's Services Award, the Health Professionals Award, the Pharmacy Industry Award, and SHADS are being looked at on gender undervaluation grounds. In other words, they are traditionally female-dominated industries. Have the minimum wages there been set at a lower level than male-dominated industries such as, building and construction, etc. And if so, should the pay rates be increased under those awards? So that will obviously have a major impact on employers if those decisions go ahead. Number 7, the SHADS Award, which of course applies to community services providers, etc., there's a number of applications to vary it from employer groups and unions, dealing with changing the rules about breaks between shifts, how sleepovers work. So we should get a decision on that quite early in 2025, I should think. So watch that space. And then number 8, the Nurses Award is being reviewed on work value grounds. In other words, have the work of nurses, has it become more complex in recent years? Does that mean that the pay rates should go up? That will obviously have a big impact too. And then lastly, 9 and 10, all awards are being reviewed generally for work and care. In other words, do awards support care providers, so parents, people caring for a relative? Are they set up in a way that supports employees doing that, or should they be amended to provide greater rights for employees in that area? And lastly, and I think this will be a big one, do awards generally provide enough protection in the way of job security for employees, or should they be amended to provide for greater job security? Now, what that will end up looking like, we don't know yet, but you can imagine that some of the things which might happen is it might be harder to engage a award employee as a casual, because obviously engaging someone as a casual doesn't provide job security. Are they going to make it harder for us to do that? Will it be harder to dismiss an award covered employee? Obviously dismissing someone is something that goes against job security, if that makes sense. So early days on those things, but that is another review that is going on for awards generally. So there'll be lots and lots happening in awards in 2025. What else is changing? And this is the kind of final slide, is various other things. Superannuation will be paid on parental leave pay from 1st of July 2025. So parental leave pay is a government-funded benefit for certain employees. It's means tested that they get when they're on parental leave. Super will have to be paid on that entitlement, which employers will have to meet the cost of. Number 2, there is talk about potentially limiting the ability to restrain employees in their post-employment life. It is already against the law in certain countries in the world to stop an employee moving to a competitor. That is being talked about a bit over here. Should we introduce a national labour hire registration system is also on the agenda. Menopause leave is being discussed in certain circles, and new rules on employee privacy and surveillance too. And then there is currently a bill before Parliament, so this looks likely to happen too, that employers with 500 or more employees will have to set and publish gender equality targets. So, how they address gender pay gaps, how they constitute, females in positions on their board, for example. They're going to have set themselves targets about those sorts of things and publish those so everyone can see them. That is the proposal. And then, of course, looking ahead to July 2026, payday super. So rather than paying superannuation quarterly, it'll have to be paid on payday. So that will be a big change, but lots of time to prepare for that. That is all I'm saying about 2025.
Cool, Simon. Cool. And here I was thinking that it would just be, oh, just a couple of updates, when I asked about what's changing. That's a lot. It's a lot to be aware of. And some things that I'm sure are not on anyone's radar. They would have had no idea, especially that last slide that you just put up.
Yeah. And can I just say one thing, Sanam, before we do this next poll?
Yes.
Which is a lot of the stuff we've talked about in 2025 is about awards, changes to awards, etc. So much of Australian employment law and obligations is dictated by what awards apply to your business, most importantly, the minimum wage. The majority of employees in Australia are covered by a modern award. That's a fact. But I talk to a lot of business owners who take the view that there is no modern award that applies to their business or their employees. And not everyone that I could speak to can be right about that. So I would just encourage you, when we're talking about making sure you're paying your employees correctly, etc., particularly if you've taken the view that there aren't awards that apply to your employees, I would just encourage you just to maybe revisit that, get some advice on that, because the awards are wide-reaching. There are industry awards, there are occupational awards, and there's the miscellaneous award, which sweeps up everyone else. Yes, there are some employees who won't be award covered, but lots and lots are. So I would just encourage you, just to get whatever advice you need, or do your research. Just make sure you are confident about award coverage, and that is obviously a brilliant segue into this poll.
That's right. And the poll, we've gotten some interesting feedback, and a lot of people, 82% of you have actually gone down and sided with the path of, I know some or all of my employees are award covered, which is always great that who applies to what, and then also they understand which awards apply to them as well, which is a really good position to be in. But like Simon has mentioned, it's really important to understand the ins and outs of it, at least from an employer perspective, so that you're not landing yourself in hot waters with all the changes that are coming in, not only on the wage theft side, but also looking at all of the other rights that they get under the award, which sit separately to what we would see generally, provided under the NES and things like that. So absolutely have a good look into it. Thank you so much to everyone for participating in these polls. We love to get this kind of feedback to see what everyone is dealing with. What we will do is we'll kick off the Q&A, Simon, if you're ready. I'm just getting a bit flexible here because we've got about 77 things that have come through. I've tried to answer things here and there. I'll keep to as many and as quickly as we can. But before we get into the Q&A, I realize that we actually have one more bit that we have to discuss, don't we, Simon? It is something very important that is something that you are quite heavily involved in, and it is the HR advisory side. So could we touch base about that and quickly cover that off, because it is a service that is just amazing.
Yeah, well, just as a shameless plug for our services, there's loads of ways that you can stay ahead of the kind of compliance game. But one of the things that we provide at Employment Hero, one of the things I look after is the HR advisory service. We've been doing it under the Employment Innovations brand for about 7 or so years. We've built up a brilliant team of HR advisors. We're really passionate about all this stuff, and it's a team that I look after, and I'm really kind of proud of the team that we've built up. But it's basically a service where you can get access to unlimited HR and employment law advice, and as well as that, of course, template documents. We'll do a compliance health check when you come on board, and you get represented in the event of a claim by an employee. So if you are, it's great for small businesses. We have loads of small business clients, but it works really well for. But equally, if you are a HR person yourself and you need a service where you can bounce ideas around with someone, or leave us with the compliance type questions, and you can concentrate on the kind of strategic HR stuff, we'd love to hear from you. I think it's a great service, and always looking to grow it and to help more businesses that we can. But yeah, should we take a few questions? We're at time, so what should we do, like a few extra minutes? And
we'll do a couple of extra minutes. I've got some easier ones, Simon, that I'm going to throw your way. I think generally we've got the answer for them. A lot of people are asking, do we need to have a right to disconnect policy? Do we need to have a clause in our contracts? I would say there is no need in terms of a requirement under the law, but it is more so about making sure that you've covered yourself off as an employer. Am I right in saying that, Simon?
Yeah, I mean, there's no requirement to have it in a contract. There's no requirement to have a contract, full stop. There's no requirement to have a policy on it. But I think and if you were a business where you work 9 to 5 and you never need to contact your employees outside of work hours, then don't have it. But if you are in a business where a degree of out of hours contact is required to make your world go round, then you need, I would suggest, you need to make that a condition of employees coming to work for you. Number one, in the contract, you want to make clear that they've signed up to come and work in this great workplace of yours. But one of the things that is a condition of them coming to work there is that there will be a degree of out of hours contact required from time to time, only in as far as reasonable, but it happens. So I think you want to put that in the contract, and you want to make clear. And part of the reason why we pay you what we pay you is the expectation that sometimes we're going to need you to jump on a call or deal with an email, whatever it is. So I think you can have something very general in an employment contract. Of course, we've got clauses we can give you to do that. But then, in your policy, I would set out the details of what sort of out of hours contact is required. And I think the other thing a policy can do is it can tell your staff, how they should be approaching contacting their colleagues. You don't want them contacting people outside of working hours unless they have to. So the policy should set out those sorts of rules as well, I would suggest. But yeah, no absolute requirement, but best practice, I would say, have a policy and have it in your contracts too.
And all this is pointing to is less headache for you as an employer, and also less worry and setting expectations when it comes to your employees. And just to tie off the right to disconnect, one of the other things that came up as well, Simon, was around, whether the contracts currently that are in place, if you did have somebody in a senior role, would you just do a simple variation to those contracts by adding in that clause?
Yeah, I mean, this is always a bit of a tricky issue, because the whole nature of an employment contract is that it's an agreement between two parties. So you can't force anyone to sign a new contract. So it's always a bit of a tricky issue when you're talking about existing employees. But you would have hoped that people, particularly senior people in your organization, will appreciate what you're trying to do here, and so they will be, you know, happy to sign off that kind of variation. The other approach that businesses sometimes take when they want to get something in the contract, which they think there might be, some questions asked about or some pushback on, is do it at the time when you're introducing some other benefit. So if you have a yearly pay rise that you pay to employees, link it to that. Say, we're giving you a pay rise this year, but a part of the condition of you doing that is we want to include this provision in your contract about right to disconnect. So you can always try and tie it in with that if you think there's going to be some pushback.
Perfect. And what I'll do is I'll just ask the last probably one or two questions, depending on how long we take. Simon, with the wage theft legislation, is super covered as part of the wages, or would it just be the salary or the wages that you're paying?
Yeah, it's a good question. I
My gut feel says yes, any any payment, but then
yeah,
again,
I'm pretty sure because it's superannuation was recently brought into the national employment standards as something which employers which forms part of those obligations rather than sitting outside of it. So I'm pretty sure that super is going to be covered by that too. But we will, we'll confirm that in the post-webinar comms.
Oh, perfect. And last one was just around the casual information statement and providing this to employees. Someone asked if there is a place where you can access the statements. Yes, if you don't use the Employment Hero platform, then you can go onto the Fair Work website, just do a bit of Googling and it will, definitely come up, and you have a PDF and a Word document version as well that you can download. Is that right, Simon? Have I got it right? Hopefully.
Yeah. I mean, if you're using Employment Hero, we'll of course you can access it through that. But I think the important thing to remember with the casual employment information statement and all the information statements, there's a general one for all employees, is they change all the time, at least once a year, because they refer to the current minimum wage, but they change whenever there's a change to the national employment standards. So make sure you have the right one. So I would suggest that if you were getting it from the Fair Work Ombudsman site, every time you're issuing it, go and get it from there every time to make sure it's up to date. Obviously, if you're using Employment Hero, we keep across these things and we make sure the ones in there are always the most recent. But they do change, at least once a year, but sometimes multiple times.
Yes, this year has been an interesting one. There's been a lot of changes. I think November was actually the last change that we saw in a couple of the statements. So absolutely, Simon is right. Keep an eye out for that. What I will do is we still have questions coming in, but I will have to wrap this webinar up. Thank you so much to everyone that has participated in the polls and for everyone that has joined us today. I know that we've got a lot of questions that are sitting there, and we will try to get to as many after the webinar through an FAQs that we'll send out, and the lovely Simon Obee will definitely be there to answer any questions you have. And if you need any specific advice, any legal advice around being, an employer, an employee, please reach out to Simon. Amazing lawyer. I can't say anything but amazing things. So please absolutely do. A survey will pop up after we wrap everything up. Please participate so that we can get some feedback on what we should do, we shouldn't do for next time. And hopefully, our personalities are shining through. So it's all gone great. And like I said before, this is all recorded, and we will be sending out some post webinar fact sheets and information. And the cool thing is a lot of different guides that Simon's team is putting together, which is amazing and probably a little bit less confusing than what's out there online at the moment. So definitely keep an eye out for that. Simon, thank you so much again for being here. We really appreciate this all the time. And I hope that you have a lovely afternoon as well as everyone else. Thank you so much for joining today's session, Simon.
Thanks, Sanam. No, that was great, and yeah, thanks to you for hosting as ever, and thanks to everyone for your attendance. And if we don't speak to you before, have a great holiday season, and yeah, look after yourselves, and we'll speak to you soon.
Oh, sounds fantastic. All right. Thanks so much, everyone. Happy holidays.